a rental.
Yeah.
Okay, let's talk about Lehman Brothers a little bit. I don't have time to go through and tell the entire story, but the reason I do want to spend a few minutes on it is because it does preview a little bit what we're going to be talking about with bankruptcy next week. And it makes the connection between what we're talking about today, secured transactions and negotiable instruments, and bankruptcy. And I have this this diagram, which I'll show you next week. But I don't know if I showed you this before. But I like to do it like this. Have I done this for you before? No. Okay. So these are assets, liabilities, and equity. And we'll be looking at this again next week. So, all right. So what I'm trying to do here is visually show you. Remember the balance sheet formula, right? Assets are equal to liabilities plus equity, or assets are equal to, or equity is equal to assets minus liabilities. So this box kind of shows you how that fits together. And if you think about a firm's assets, they get the capital to buy assets either from borrowing money or from equity. Now, what happens when a company goes, often what happens when a company goes bankrupt, not always, but this was certainly the case in Lehman Brothers, the value of their assets dropped in very unexpectedly and very sharply. And so why is that a problem? Well, a firm like Lehman, oftentimes a firm like this is 50-50, right? About half liability, half equity to finance the assets. Most financial firms are far more leveraged than this, meaning they have a lot more debt relative to equity. And so in a firm like Lehman Brothers, towards the end, they were among the most highly leveraged firms in the country. And I think it was almost like 40-1 or something like that. And so equity was way down here like this, and all the rest of this was debt. Okay, so this is what the picture looked like for Lehman Brothers. And a lot of this debt that they had was commercial paper. It was a big chunk of that $1 trillion that floats around the system and makes the system work. Well, what happened in 2008, Lehman Brothers was super heavily invested in mortgages. In fact, in my day, when I used to be in the subprime business, Lehman Brothers was different than the other street firms. They would actually go buy mortgage companies. Most of the other firms would just buy mortgages from mortgage companies. Lehman would go actually buy those companies. So it was in the business of actually making loans, not just buying them. And so it had a huge number of these loans on its balance sheet. Now, what happened was these loans started to go bad really fast when the market collapsed and appreciation dropped. So for, what it was, 15 years, home prices did this. And so you could borrow money here, and then when about a year later, your house was worth more and you could borrow it at a higher rate, pull more money out, and it kept going up. But then what happened was it went like this. It just dropped. And so the value of the assets that Lehman had fell dramatically. So let's just say, for example, it falls to this level. Now, because they have so little equity, they are now dramatically underwater. They have far more debt outstanding than assets. And that happened so fast that they couldn't solve the problem. They couldn't fix it. It was too big and too fast. And once word got out that they couldn't meet their obligations, people stopped lending to them. And can you imagine if you have hundreds of millions of dollars of commercial paper that you need for cash, and then all of a sudden people stop lending to you, and your assets are now worth a fraction of what they were before, you can't get any money, boom, you're bankrupt. And that's exactly what happened to Lehman, and that's exactly why Lehman was such a big deal, because the government didn't rescue them. They rescued Bear Stearns earlier that year, and then said, no, but we're not going to rescue Lehman. And when they did that, everyone said, oh boy, this is a much bigger problem than we thought, and nobody wanted to lend into the commercial paper markets anymore because of this problem. That's why it was such a big deal. And we're going to talk next week about what happens to a company when this problem happens. That's what bankruptcy is. It's a way to resolve this problem in an orderly way, court supervised, orderly fashion. Okay, does that make sense? As a little bit of a preview for next week. Does that make sense to everyone? Any questions on that? Okay. You'll be reading about Lehman Brothers for a long time. I mean, it's now been over 10 years and we still talk about it all the time. Okay. So just in the interest of time, we'll go through this quickly. So remember, commercial paper is just a form of a negotiable instrument, short-term cash equivalent used by large companies. Remember, it has to be in writing. It has to be for a specific amount of money, due in a specific amount of time, signed by the parties. Remember, it has to have all those elements to it. And the general rules are these things like, if it can have multiple payees, who has the right to fill it in, if it's blank, that sort of thing, all those rules. I'm not so worried about this one. I just want you to know that they're out there, not so much that you know all those minor rules. Okay. All right, so let's talk about secure transactions. Okay, I think we're okay on time. So we're going to talk about what a secure transaction is. I sort of already explained it a little bit. Then what we mean by a security interest. We're actually going to look at some examples of this, and then we're going to talk about what we mean to perfect. That's when you read this sentence, it's not how do you perfect a security interest. It's how do you perfect it. It's called perfection, and it's just a legal term of art specific to the UCC. Okay, so this diagram tells us a little bit about. I don't know why it keeps doing this. I just fixed that. Okay. Anyway, this is where autocorrect drives me nuts. I'm like ready to turn it off because it should have 2 E's on the end of that. And I fixed it and then it put it back. All right. This is a diagram that sort of describes how a secure transaction works. So you have the debtor or the obligor, the person who's borrowing the money. They borrow the money from the creditor. Okay, so I am a debtor to KeyBank because I have my mortgage with KeyBank. So KeyBank is the creditor, and I'm the debtor. Now that was a bad example because that's a real estate transaction which isn't governed by the UCC. But from a generic standpoint, secured transactions are all the same. They all have a debtor and a creditor, or at least one debtor and one creditor. So the creditor lends the money, the debtor makes a promise to pay it back. And that promise is reflected in an agreement, in 2 kinds of agreements. There's actually 2 separate agreements that are needed to make this work. The first one is a note. The note is the document where the debtor says, I promise to repay. I agree to borrow the money and I promise to repay it in this amount of time with this amount of interest. That's called a note, right? Now the note by itself, if we just had a note, what would we have? What kind of transaction would this be? Unsecured transaction, right? Exactly right. It would be unsecured. What makes it secured is the security agreement. This is an agreement where the debtor says, I, debtor, am giving you, creditor, an interest in my property. You have, it's like an ownership interest, except it's only triggered if I don't pay back my debt. Okay, so I have a car. I bought a car last year, a Hyundai Santa Fe, and I would have just paid for the car, except for the fact that Hyundai was willing to lend me money at 0.9% interest. And if they're willing to give me money that cheap, I'd rather keep my cash and pay them 0.9% interest, right? I'd rather use their money for that cheap, so I can invest my money and make more than that. So I borrowed the money to buy the car. So I signed a security agreement. I signed a note, my promise to pay them back, and I signed a security agreement that says, Hyundai Motor Finance, you have a right in my car. It's my car, I own it, I'm the titled owner of it, but you have an interest in it. If I don't pay you back, you can come and take it back from me. Okay, that is called a security interest. It's also called a lien, L-I-E-N. So Hyundai, and maybe what I'll do for next year is I'll take a picture of my car and then a picture of me, and then I can make a diagram using my car. Okay, so I borrowed the money from Hyundai Motor Finance, and I bought the car from Hyundai, and I now owe money back to Hyundai Motor Finance. I signed this piece of paper. Okay, so now Hyundai has attached my property. They have an attachment to my property. That's what it's called. They have rights in my car, which is the collateral for the loan. Okay, so my car is the collateral. I own it, but the creditor has an attachment right to it if I default on the note, because the security interest gives them that right. Yes?
So is it the same like on my car? It says like you are like the registered owner.
Yeah.
And then the bank is the legal owner.
Is the legal owner or the lien holder? Yeah. It's different terms in different states.
Okay.
Yeah, but they call that. It's on the title, right? When you get the title to your car, it says that there's a lien holder on there or a legal holder, depending on just different state terminology. And the reason they do that is because if they didn't do it, you'd be able to sell the car, right? You'd be able to sell the car and they would lose their attachment to the collateral. So the way that they protect their interest is by putting that on the title, and the Department of Licensing is not going to let you transfer the title to somebody else without first paying off the lien. Okay, and that's how they protect themselves. The other way they protect themselves is if you don't pay them, is they come and take your car. They can repossess it. But they have to actually do that. They have to actually go and repossess it if you don't pay. And that's not such an easy thing to do because cars, by definition, are mobile. They're easy to move around. So they're hard sometimes to go find. So there are people out there who specialize in tricking a debtor who hasn't paid into bringing their car someplace where they can seize it. Now, I used to work in a building once where a company, there was a repo company, and what they would do is they would call up these people and make some story up to try to get them to come in, and then what they would do is have somebody else in the parking lot, and when the car pulled in, they would pull another car behind it so it couldn't get out, and then they would ask them for the keys. So you legally have an obligation to turn it over or to pay the debt, but they can't. It's not criminal to not pay a debt, so they have to go through their own methods of repossessing collateral. Now, have you ever seen when you drive down through downtown Tacoma all those bail bond companies? You ever see those? And you know how bail bonds work? Hopefully, don't tell me if you know, maybe. So a bail bond is if you get arrested and the judge sets your bail at $1 million. We don't have $1 million. You can get a bail bond company to put $1 million up for you, and you pay them a fee for it, and they will usually take some collateral for this. An interest in a house or whatever. You have to usually put up some sort of collateral for that what is effectively a loan on your behalf. If you don't pay a bail bond, then the law allows the bail bond company to go try to find you and arrest you. They can take physical possession of you and return you to the court to get their money back. All right, so, but the point of it is, a creditor has rights in the collateral only because of the security interest, not because of the note. So don't make that mistake. Just because if you lend somebody money and they write a note back to you saying, I promise to repay, and they don't pay, unless you have a security interest, you have a security agreement, you have no collateral, no rights in the collateral. So those are two separate agreements. Okay, Article 9 covers pretty much any kind of transaction with collateral except for real estate. There's other things that are excluded that we don't need to get into here, but when I borrow, that's when I said earlier the key bank example was a bad example. It's because that transaction is not governed by Article 9, it's governed by the common law because it deals with real estate. Article 9 deals mostly with personal property, but it also deals with things like sales of accounts. So if you if you are owed money, so let's say you have that's called an accounts receivable. You sell something to somebody and they agree to pay you in 30 days. You can actually sell the right to receive that payment to somebody else. That also is an Article 9 transaction. Chattel paper is an example of that. Is what we just talked about. A bearer bond, for example, is a form of chattel paper, and that could serve as collateral for a loan. So, and it would be governed by the UCC. And then you could also borrow against intangible assets. So patents, copyrights, and trademarks. That's very tricky and very complicated. I did a deal when I was at Guess. We borrowed money against all of the receivables for all of the licensing deals we had. So I don't know if you know this, but if you buy a Guess watch, all watches are basically made by one or two companies. Timex makes almost all watches, actually, including those with the Guess brand on it. Luxottica makes pretty much all eyeglasses, including those that have the Guess brand on it. And when you have a brand that people want, you can license it. And one of the most profitable parts of Guess's business was this little office that had like 7 people in it, and all they did was license the Guess name to all these companies who wanted to put it on all these different products. Well, so that generated a stream of income, but we needed cash to finance our operations, and so we needed to pledge an asset for this loan. So we pledged the right to receive all these licenses, all these license payments as collateral for the loan. So the actual contracts for the receipt of the license payments was the collateral for the loan. So that would also count under UCC. If you can think of it, if something has value, you can borrow against it, pretty much. One of the companies I worked at once in the go-go days like this, we were super heavily leveraged like Lehman was on a smaller scale. But the executives, the reason they wanted to do this was they wanted to make more and more loans to make more and more money, so they just were trying to leverage as much as they could. We actually borrowed against the software system that we had that ran our loan origination system. We spent $10 million to build it out, and so we borrowed against it. So if you have something, any kind of an asset, someone will probably lend you money against it. But the harder it is to collect, to seize, the riskier that loan is and the more it's going to cost. But in general, secured transactions cost less because there's security behind them, but not all secured transactions are the same. Depends on how risky and how difficult it is to seize the collateral. Okay, it does not apply to a bunch of different stuff. So there's some other laws that just preempt Article 9. Non-agricultural landlord liens, doesn't apply to that. A sale associated with the sale of a business, of what we call a bulk transfer, that doesn't count. Assignments, and then of course real property. So there's a bunch of stuff that it doesn't apply to, but just remember, for the most part, tangible personal property, when you borrow against that, that's UCC. Okay, how do you create it? So we saw the security agreement, right? You have to, the creditor, go back to this slide here, the creditor has to give some value in exchange for the right. So if you can't just say, hey, can you give me an interest in your house? I mean, you can do that, and if you're dumb enough to do it, then that's fine, but it's not going to be governed by UCC. Again, bad example. If I say I'm going to give you a security interest in my car for fun, and I could sign a security interest and give that to you, it would have no value. It would have no meaning unless you gave me some value for that obligation. And then this is important. The debtor has to actually have rights in the collateral. So I can't take a loan out on your car because I don't own your car. So I don't have any rights in your car, so I can't pledge them as collateral. Okay, so the debtor has to have the right to do that. And then either the creditor has to hold possession of the asset, or there has to be a security agreement. So I showed you earlier in this slide, oops, sorry, wrong way, I went the wrong way, that there has to be a security agreement. There is a way to avoid a security agreement if the lender actually holds possession of the collateral. That doesn't work for a car, right? If you're buying a car, I don't want Hyundai to hold my car for me until I pay it back because then I can't use it. So you need to have a security agreement if the lender is not otherwise holding possession. So in most cases, there's a security agreement because it doesn't make sense for the lender to possess the collateral. Although in some cases, one company I worked for, we borrowed against a bunch of bonds that we had. And I remember there's this crazy situation where it's one of these deals where this deal had to be done. We needed the money, we were close to failing, and we needed the cash, and we were kind of doing this last minute deal. And our CFO was in New York anyway. And the bonds that we were pledging, they're actually on physical paper. They were physical bonds on what they call security paper, which means you can't modify them without noticing it. And but they were in a vault at our broker in New York. And the lender wouldn't lend to us unless they had physical possession of the notes. And so we had to we were on the phone with our CFO, and we're like, David, you need to go, where are you? And we figured out he was only a few blocks away. So we made him leave his meeting, walk over to the broker, take the bonds, walk them over to whoever it was, Lehman Brothers or whoever we were borrowing from, and physically hand them the collateral. They wouldn't wire the money unless they had possession of them. Because they wanted to know if we didn't pay, they could turn around and sell them. They didn't want to have to come after and get them. Okay, so sometimes the lender does physically hold the physical possession of the collateral. Okay, so perfection. So this is the part that's a little more fun. Okay, so it's not enough to sign a security agreement. That does create an attachment for the lender, but there is a more senior position that you can have in priority if you perfect your security interest. So a security interest by itself can sometimes be non-perfected, and it's still a security interest. It still gives the lender rights in the collateral, but they are lower level rights than a perfected right. And a perfected right is one that has been filed with the state. And so there's an actual public system where you file a UCC financing statement. It gets filed with the state where the assets are located. And basically what it does is it puts the whole world on notice that someone has a security interest in this property. And by doing that, in exchange for that, you have a lender who does this has a senior claim to anybody else who has not perfected and to anyone who perfects later. So it's whoever's filed first has the most senior claim. This becomes important next week when we talk about bankruptcy, because when there aren't enough assets to pay all the liabilities, we have to start rank ordering the liabilities. And perfected rights have senior priority, unperfected rights are second, and then unsecured loans are at the bottom, and then the real bottom is the equity holders. They almost always get wiped out in a bankruptcy. Okay, so they're good for 5 years, and then they can be continued. So I'll show you what they look like, because you can look them up on the internet. Hopefully this will work, okay? So this is Washington State's UCC filing system. And let's see if I can do this correctly now. We're going to search the records. And this is available for anyone to look at. We're going to look at a debtor that's an organization. We're going to look at Pacific Lutheran University. Okay? And then we're going to, I tested this and it worked the last time I tested it. So let's see. Okay, so here's all the UCC filing statements that are on file for the university. And there was one, where's that one? See, some of these you can't look up, they're paper records, but some of them are available. So this is what, notice it says up here, it says UCC financing statement. Okay, so we all know what this is, right? It was filed on August 12th of 2010, and it's good until 2020, unless it's terminated. Okay, so Pacific Lutheran University, we're the debtor for this. Now let's look and see who the creditor is. Creditor is U.S. Bank Corp. So we borrowed some money from them. And let's see. Okay, so what they did here, they're not telling us what the asset is. It's part of some document, some other reference document. So this one's a little harder to tell what it is. So let's look at another one. This is an amendment. This is an initial. Let's look at this one. Okay, again, they just are referencing other documents. Oh, here, icon. Here, this is the one I always wanted to show you. Okay, so this one, and oh, that's a little hard to see. Okay, this one, we're the debtor. Icon Financial Services. You ever hear on the radio during Mariners games? Icon copier. They sell copiers and copy equipment. And so you'll notice here it says this is the description of the collateral. It says the debtor and the secured party shall mean lessor and lessee respectively. This covers the following types of property. All equipment now or hereafter leased in an equipment leasing transaction in connection with the master agreement as amended. So there's this agreement, and if you looked up this agreement, you would be able to see what it is. And it's probably a copy machine or something like that. Somewhere in here is a financing statement for some equipment in the gym. And see if I can find that one. I thought I had it. Yeah, see, oh yeah, okay, look at this. This is where we financed the property is including, but not limited to, heating and incinerating apparatus and equipment, boilers, engines, motors, generating equipment, telephone, and other communicating systems, piping, and fixtures. So we made some improvement here in a building, and we borrowed the money to do it. The HVAC system maybe, or the incinerating apparatus, maybe that's the kiln in the ceramics area, whatever. If you borrowed against that, this is telling you that this property is subject to an interest from Washington Federal Bank. Okay, so that's how you can tell. So if you're going to lend money to somebody based on their personal property, what would you do? What would you have to do? What would you want to know if someone said, I have this copy machine and I'd like to borrow money from you and secure it with my copy machine? What would be the first thing that you would do? Yeah?
Someone has interest in the same.
Yeah, you go, right, so you would go search. You would go search the UCC records, and you can search them by the debtor's name, or the creditor's name, or a filing number. You can search by all these different bases. So one of the things that has to be done before a loan like this is given is a search is done to make sure that nobody else has a lien that is senior to the one that you're going to give. Because you want to know what priority interest you have in that property. And this is a public system that allows you to do that. All right, any questions on that? Okay, so why do we care? It's very important because almost all of this office equipment that you see in office buildings is subject to some form of UCC lease transaction. It's not common to have companies use a bunch of their cash to go buy a copy machine, right? It just doesn't, it's just not a smart use of capital. So you lease it instead, or you buy it and finance it. And it just makes it's a much better use of capital that's been given to you. It's used for cars. It's also used for airplanes. Most airplanes are leased. Right? Did we talk about the A380 in this class the last time? Do you remember that? Right? We talked about that. So airplanes are leased all the time, but airlines often don't own them. They lease them from a leasing company so that they can put their collateral, their capital into running their airline. In fact, it's even a new thing now where the airlines will lease the engines separate from the airplane. And the engine companies are starting to do these systems where they pay for use. So the airline only pays for the engine while it's being run. And then, and if they use it more, they pay more. If they use it less, they pay less. So they're, all of this stuff is finance. I worked on a deal once. This is another problem with leases. The company I worked for, we had a Gulfstream 3, a 1982 Gulfstream 3, which was the CEO's toy that he had bought for himself when the company was doing really well. And in fact, we were a mortgage company, and his wife spent $15,000 to have the name of the plane stenciled on the side of it. And it was called, and he had been he founded this company, and it was a loan company, so they called it the Loan Arranger. Because he was a loan broker, and so the plane was the Loan Arranger. $15,000 of shareholder money went into that. Well, when the company was in trouble, I don't know if I told you about this. I think I told this story. That airplane, the board said no more. We're no more using it. It's too expensive. It costs $5,000 an hour to fly it or whatever. Forget it. No more use. Well, the problem with it is it cost us $250,000 a quarter to park it, to not use it, to hangar it, to maintain it, to have the crew and the maintenance people. So it was $1 million a year to sit still. The problem with it was we owed more money on it than it was worth. The remaining lease payments were more than what we could sell it for. So we kept trying to tell the leasing company, look, we don't want this thing, take it back. It's gobbling up resources and we want to get rid of it. And they said, no, we're entitled to all of the remaining lease payments. And they wanted us to pay them the remaining lease payments, which were more than the plane was actually worth. So we would have actually had to write a check to get out from under the airplane. And so we leased it out, and the Moody Blues took it on a concert tour. And we tried to make some money to offset the cost until the lease payments came down to what it was worth, and then we sold it and paid off the lease. But it just gives you an example. And you see those private jets, a lot of them are subject to these kinds of transactions. This point, cost of borrowed capital, and I've sort of mentioned it already. It's really important to understand that when you have, if you have assets that you can borrow against and you need money, you can save a lot of money by pledging collateral. It's secured debt is much cheaper, in most cases, much cheaper than unsecured debt. However, at a certain point, when you have all of your assets have been leveraged, then there's nowhere else to go, and all that's left is unsecured debt. And unsecured debt is very expensive. We're going to look next week at the Sears bankruptcy, and I don't know if you've been following it, but there is a market actually to lend money to bankrupt companies. It's called debtor in possession financing, DIP financing. And the reason that there's a market for it is that the court has the power to give super priority to somebody who finances a company in bankruptcy. So a company can come in and lend money and be at the very top of the priority list if they will lend to the bankrupt company. But they can set their terms, and they're paying 15 or 16 or 17% interest, plus they had to pay a fee to borrow, and this is to keep the stores open during the holidays. So there is always debt available, it's just how much you want to pay for it. And the more leverage, the more you use collateral to borrow, the cheaper your cost of borrowing is going to be. And that's why this is so important, because you will, as a business person, almost certainly need some form of business financing. And then last, and this is kind of what I talked about here with Lehman Brothers, this is what we call leverage. And the reason it's called leverage is that in this case, Lehman Brothers, for every dollar of shareholder equity, they could buy $40 worth of assets. And that's great when you're making money, right? Because if those $40 of assets are making money, that's awesome. But if those assets lose value even just a little bit, you go bankrupt really quick. And so it's important to understand that in order to maximize profits, you need to leverage. You need to borrow money to maximize profits. But if you borrow too much, you turn yourself into a much riskier company. And so there's a balance between how much leverage you want to take versus the risk that you're taking. So how much profit do you want to make? And if you work for a company with shareholders, they're going to want as much profit as they can get. And in the good times, they're going to say, how come you're making less profit than the company next to you? They'll be willing to take much more risk. But in the case of when things go bad, then everyone questions why you have so much debt. So it's a really, really risky balance that you have to manage as a business owner. Okay, I think, let me see, I think that's it. Why do you care? Yeah, okay, what? Yes, you excited? I know this is not the most exciting material, I get that. So we'll cut out here. Have a great Thanksgiving. We will see you next Tuesday morning.
Yeah.